Afternoon, and welcome everybody. My name is Jim Boutros. I'm chair of the Labor and Employment Practice here at McDonald Hopkins, and it's my pleasure this afternoon to be presenting with my two partners and colleagues, Miriam Rosen to my immediate right from our Detroit office, and then Nicole Gray from here in our Cleveland office. Today is, thank you for joining the Business Hour. This is the first in our Employment Law Risk Management series, avoiding the common mistakes that employers make. And this program is dedicated to avoiding mistakes that can lead to a governmental investigation. And for those of you with your calendars handy, I want to give you the dates for our other programs that will be coming up in this series. May 7th, we're going to be talking about avoiding mistakes in handling and administering FMLA leaves. On July 24th, we're going to be talking about avoiding mistakes in handling ADA situations. And then finally, on November 13th of this year, we're going to be talking about avoiding mistakes in the termination process and in terminating employees. Throughout today's program, and it's nice to see familiar faces, so many of you know this, but during the program, if you have questions, we encourage questions. We find that it makes it a more robust and fruitful discussion and presentation. You have cards for those of you here in Cleveland. Please write down your question, raise your hand, and then one of our marketing staff will pick it up and bring it up to us, and we will address the question. For those of you in our web audience, you have an icon on the webcast. Please click it. It would allow you to submit a question. It will be brought up to us, and we will answer those questions as well. We do our very best to answer all the questions, but we also want to be respectful of your time, and we do want to finish on time at 1:15. So to the extent that we don't address a question, for those of you here in Cleveland, and if you have a little time afterward, myself, Miriam, and Nicole will stick around and answer any questions that you may have. And for those of you in our web audience, we will get back to you via email and address your questions. Also, for those of you that, all of you who registered for the program, you now have a temporary password, lucky you, to the Business Advocate. And that's where we post articles, comments, etc. regarding the latest developments in labor and employment law. We invite you to join our community to the extent you haven't already and join the discussion. That's where you'll find reproductions of this program, for example, amongst the other ones that we put on. And again, we'll have an ongoing dialogue regarding the issues that you're facing day to day with your employees. And last, and very importantly, you will be getting an email survey relative to today's program. We really welcome your feedback. We're always trying to improve the program, so please take the time to fill it out. Also, other topics that you may want to hear about, we'd like to tailor our topics to those that are of most interest to you. So again, please take the time after the program to fill out the survey. We do take those comments to heart. So let's begin. Again, we're talking today about avoiding mistakes that lead to governmental investigations. This entire series, the series that I just outlined for you, the series of 4, we're going to be highlighting key issues in these respective areas and bringing real-life scenarios to these topics so that we have real-life application, things that you can apply to your workplace right away. Today, we're going to be focusing on, in particular, Miriam is going to talk about issues involving the Department of Labor and the FLSA issues. I'm going to be talking about conducting internal workplace investigations when complaints arise. And then Nicole is going to focus on external charges, EOC charges, civil rights charges, and also conducting internal audits to make sure that your employment practices are up to snuff. What's the backdrop for today's presentation? And that is, and somewhat consistent with the State of the Union address. I remember Miriam and I, back in 2008, right after President Obama was elected, there was a battery, and those of you here may recall, of employment legislation that was on his slate, very pro-employee legislation that he was seeking to get through. Well, I guess consistent with what's transpired in Washington over the past 6 years, definitely didn't have the bipartisan support to get that legislation through. And so what has happened in practice is the administration has basically turned it over to the governmental agencies, okay? and federal, state agencies, we found that they've become much more aggressive, much more intrusive, and the investigations, which used to get, I won't call it lip service, but you could get by fairly easily, you can't any longer. So what the administration couldn't do vis-a-vis legislation, they are doing through the agencies. And here's some statistics that put this into context. Since 2009, Department of Labor has added a significant number of investigators and has been focusing in particular upon industries and the restaurant industry, garment manufacturing, healthcare, hotels. For those of you in those industries, you know what I'm talking about. Last year collected $250 million in terms of penalties and fines. Likewise, the EOC in 2012 announced its systematic initiative in terms of targeting an aggressive focus on investigating claims, in particular in the hiring context, disability, equal pay claims, pregnancy, and religion. You know, in particular in hiring, for those of you that may be aware, we've seen a lot of activity relative to background checks and the alleged disparate impact that has in the hiring process on minority groups. So the EOC has been very aggressive in that regard. Also seen quite a bit in the retaliation vein as well. And consistent with this initiative, the EOC last year collected a record amount, $372 million in fiscal year 2013. Needless to say, that's something we need to be concerned about because the government is concerned about it. So what do we need to do as employers in order to avoid government investigations? Well, not surprisingly, we need to be proactive, and that's why you're all here, right? That's why you're listening on the webcast. Taking those steps to make sure that your organization is prepared through proper policies, through proper procedures, all of which we're going to touch upon today, to make sure that you are ready to handle an investigation when it occurs, when a complaint occurs. Training your managers and employees. I can't stress this enough. It's one thing to have the policies and procedures in place. It's another thing for them to be put consistently into action. So taking the time to properly train, in particular your managers, in fielding complaints and how to handle those complaints is critical. And all of this, of course, is designed to avoid governmental investigations, taking these proactive steps. So with that, let me turn it over to Miriam to talk about our good friends at the Department of Labor.
So don't you hate it when this happens? You get your mail, and there's a letter, and right at the top it says U.S. Department of Labor. And you open it up, and it's a scheduling letter, and it says the Department of Labor will be coming to visit you in 3 to 5 days, and they would like you to have a whole list of things ready to go for them to see. Payroll records for 2 years, time card records for 2 years, you know, your organizational chart. They'd like to have employees for you to interview. It's a bad day when you get that letter. But there's good news. Maybe you don't have to get that letter. And here's one of the secrets, at least. Most of the DOL audits are the result of individual employee complaints. The DOL will tell you, we can't tell you, it could be part of our targeted investigations, but at least 85% of DOL audits are the result of individual employee complaints. Well, you can't do anything about their targeted audits, but you can do something about individual employee complaints, and that's what we're going to talk about. So, first topic. And these all are going to seem like pretty common sense things, but we're going to look at some things you can do to avoid those mistakes. Misclassifying non-exempt employees as exempt. The U.S. GOA, Government Services, recently put out a study, and they said 16% of lawsuits relate to misclassifying non-exempt employees. I'm guessing that when the DOL does their audits, there are probably actually more misclassifications. How do those happen? Lots of times, the employee will complain, they may be terminated, and then they're thinking, wait a second, I did all that extra work and I never got paid. They go to the DOL. When the employee goes to the DOL isn't just looking into that one employee, they're going to do a full-scale audit. So what are some of the things you can do to avoid a misclassification? Well, you know, and you'll hear me say this a couple times, the Fair Labor Standards Act is really complicated, but there are some very clear exemptions. So when you talk to a DOL investigator, they come in with the premise that everybody is non-exempt, should be paid on an hourly basis and get overtime after 40 hours unless they fit into one of these classifications that's exempt. To be exempt, you have to meet 2 criteria, and sometimes that's where the problem comes in. What you do and how you're paid. So lots of times we hear, well, I paid them a salary, but it's not just the salary, it's what they do as well. And there's some very specific exempt criteria. Executives, they have to manage at least 2 full-time employees, be involved in hiring and discipline decisions, and some other criteria. They don't have to be the head of the organization. Sounds like executive means the head of the organization. It's not the case. Professionals, a little clearer than probably most of the other exemptions, lawyers, doctors, engineers, and our friends, the administrative employees. And that goes back to really when the Fair Labor Standards Act was enacted, administrative employees really meant something different than it does now. And that's probably the area that gets most employers in trouble. People who are involved in running your business, but what's their level of discretion and independent judgment? That's really the key. So there's some things you can do, mistakes that you can avoid to make sure that your exempt employees are really exempt. Analyze their duties and make sure they meet the criteria. Look, you look at the regulations and it's a little hard to tell, but there are lots and lots of cases and opinion letters out there that help give you guidance. So do that, number 1. Number 2, make sure that your offer letters and your job descriptions are consistent with their status. I can't tell you how many times I've seen a job description that for someone who's supposed to be an exempt administrative employee, and it really sounds like a clerical position. And it might not be a clerical position, but here's the problem. It's sometimes really hard to capture everything that an exempt employee is doing, that independent discretion and judgment. How do you capture that? So you have to, really get out your thesaurus and think about words like analyze, recommend. They have to really be doing those things that relate to the operation of the business. So, it's some of that hard background work that you need to do. And if you're hiring new people, if you can't review all your job descriptions at once, do it when you hire someone new. What else? We know that there are certain positions. I can promise you, if you have a DOL audit, they will look at certain positions more than others. IT, because IT is often miscategorized. Your help desk employees are unlikely to be exempt. Your more sophisticated IT professionals may be exempt. You have to analyze what they're doing. Assistant managers, big category of risk. Are they really exercising the level of judgment? Are they supervising 2 people independently of the manager? So I can promise you they'll look at assistant managers. And then the DOL loves the word coordinators, and I actually should have put in there specialists too. Coordinators and specialists. You need to make sure that if you're treating those employees as exempt, they're really exempt. Also look at your pay practices related to exempt employees. They have to be getting a salary. And if you get various employment law updates, you see every day wage hour lawsuits. And lots of times you might look at it and say, well, financial, I wrote a couple down just from this week. Financial advisors, loan officers, assistant managers, those all sound like exempt. HR managers even recently. Well, why might they think that they're not exempt? Because lots of times the employer mistakenly doesn't pay them on a salary basis. So even if the duties might qualify, they might not be getting the salary. So mistake number 1. Another mistake, misclassifying employees as independent contractors. So,
Marion, before we go on, relative to the job descriptions, because I know we've run into this quite a bit, what is your recommendation relative to updating job descriptions? Because as we all know, sometimes the position changes, and we're left with a description that might not otherwise accurately reflect today when it did perhaps a year or 2 years ago. So what is your recommendation relative to taking a look under the hood, if you will, relative to your job descriptions?
Right, that's a good question. Yeah. The job descriptions, if you had even asked me a number of years ago, I might have said, well, job descriptions, okay, it's not your top priority, but job descriptions are increasingly important for just that reason. So update them when duties change, or maybe even if you can't update every description, at least make a note to show that the duties have changed. I can tell you, I had a client that had a big Department of Labor audit with many kind of sophisticated financial service positions, and the job description didn't reflect really the level of duties. And at the first level, the auditor came back and said, these people are all non-exempt. We had to push back, and the job descriptions didn't help us. What did help us was going through and really showing what they were doing, and they were exempt duties. So if we had better job descriptions, at least some of those people might have come through the first round as exempt.
And I find also when you're updating your job descriptions, talk to the people who hold those positions. Ask them, what are they doing, so that your job description mirrors their job duties as close as possible. And then if in the future that individual files a lawsuit or goes to the Department of Labor, you have a way to rebut their claims that they were non-exempt when they're the one that helped you create their job description, right? And of course, at the time, they're going to make themselves sound a lot more important than after they've been terminated, or when they're faced with potential of recovering overtime wages. So using your employees to determine what's being done in the position is helpful.
I'll just throw in one more tidbit. I can't help myself about job descriptions, that they also help you if you have an Americans with Disabilities Act claim, because they support what the essential functions are. Just a little preview of things to come.
It's a teaser for
right.
July 24th. Yeah.
So, okay, independent contractors. Obviously there's a temptation with some types of jobs to just say, well, we're just going to treat them as an independent contractor. They're contractors. But it's a big risk. In fact, I just happened to be perusing the wage hour division's request for 2014 budget, because it's a fun thing to do. And it turns out that they've asked for more investigators just to focus on misclassified independent contractors. So it's important. They're looking at it. We don't always see it in practice. I haven't seen a lot of investigations, but I know they're talking about it. But again, it's one of those areas, kind of like classification of exempt employees, where there's lots of guidance out there, but at the end of the day, it's a little fuzzy. And so you probably should, get some help in assessing what the status is. The criteria are here. I mean, the criteria are well known. The IRS has criteria, the Department of Labor has criteria. But at the end of the day, are you controlling what that person does and how they do it? If you are, they're likely to be an employee. If you're giving them a project and letting them come back and give you the end result, you're not controlling their hours or how they do it, maybe you have an independent contractor relationship, which you've documented in an independent contractor agreement.
The one, I know we run into this quite a bit, is when we have contractors that are in our principal line of business, if you will. Can you speak to a little bit about the fact that that's a potential, red flag? Sure.
So when the idea of an independent contractor is they're not essential to your business. So Jim and I have had a couple cases where, this is always a tricky one, where maybe you have truck drivers. Well, if you're
it's pretty big in that industry.
If you're if you're a trucking company, well, drivers are pretty much essential to your line of business. So there are some truck drivers who are independent. Maybe they drive for more than one company. They're not tied to one company who sets their hours, owns their truck. But if you've got someone who only works for one company, the company owns the truck, they provide the insurance, and on and on and on, they look an awful lot like employees and not independent contractors.
And with independent contractors, being consistent internally with how you deal with them is important as well, so that you don't have an issue of, well, it might have said on paper that you were an independent contractor, but we really handle you, you were supervised by somebody internally, we did performance evaluations for you. Those are things that are going to lean toward an employee. And also where I've seen it come up is unemployment. we had to lay somebody off who was an independent contractor, and we wanted to help them out, so we classified them as an employee to get them unemployment. And so now we've gone on record saying you're an employee when they have unemployment, and yet we're going to argue independent contractor later.
Or I'd say even a little bit of the reverse, which is someone who we classify as independent contractor. This is how lots of times you get audited. They go and file for unemployment, and all of a sudden you've got a disconnect. One person saying one thing, the other person saying something else. So
it's interesting too when we find we have or employers that have in the same job will have employees and contractors, and they'll have part of their staff hired as or signed on as ICs, and then they have some W-2 employees that are doing the same thing. That's a danger sign as well.
All right, so obviously the biggest area for mistakes is just your general payroll practices, how you pay your non-exempt employees, tracking hours worked, rounding practices. According to GAO, 95% of wage hour violations are overtime, relate to overtime. Not surprising. It's complicated. When you say overtime, that means how you track their time, if you're accurately attributing time that should be time worked to the employees. See lunch breaks, pre and post shift work, about another 25% is off the clock work. And an area to really be looking for, I think now, is when employees who have smartphones who are responding to emails or taking calls after hours. If they're doing it for your benefit and it's anything other than de minimis, it's really time worked, and you have to find a way either to control it, employer, that's your responsibility, or capture that time. Those are the two options, control it or capture it. Travel time and bonus pay. Also issues, lots of times we see employers providing bonuses and then not recalculating the regular rate. So even though you're paying overtime, it's not at the right rate. And again, if you're looking at those HR updates, you see every single day, employers are getting hit with millions and millions of dollars. I just went back a week. I saw PetSmart, $10 million. Tyson Foods, $19 million. Settlements, donning and doffing, taking clothes off, putting them on. That's a lot of money if you can do it right. So how do you avoid those mistakes? Well, first of all, let's start with this. The FLSA is complicated. It's not intuitive. So you need somebody in your organization or a professional outside your organization who understands it and can help you. Really, your HR person or someone else in your staff should really have a good understanding of wage hour practices. Here's something else. You should audit your payroll practices, and not just kind of the surface audit. Sometimes those inaccurate practices are hidden in your payroll system. I want to give you an example. Years ago, I had a client in the healthcare industry who implemented a well-known and pretty sophisticated timekeeping system. But what was embedded in the system that they didn't understand was a rounding system that rounded in favor of the employer both ways. Well, the FLSA doesn't allow that. You can round in favor of the employer one way, but you have to round in favor of the employee the other way. What do I mean by rounding? When someone comes in a few minutes late, you can deduct that time, but when they leave a few minutes late, you got to round in favor of the employee. You can't round back to their normal end time. It wasn't even a conscious decision that the employer made. It was embedded in the timekeeping system, and I've seen lots of other examples of that. So really take a look at, go through it. You can get a checklist, and you can go through all the things that are part of your payroll and timekeeping system to ensure that you're doing things accurately, because a lot of, PetSmart, Tyson, a lot of those types of violations are things that you might not even be thinking about. I see Jim has a question.
I do, and this is one this is a position that we get often. That is, do you ever see payroll administrators or payroll coordinators as exempt? That is, the position doesn't supervise anyone, but performs a highly skilled function in the organization. So relative to that position generally.
Yeah, it's funny because I was actually going to use those as examples, those types of accounting type functions. Again, you have to go back to what the employee's doing. It's possible, but if they're processing payroll and not doing other things involved in running the business, probably unlikely. But you have to assess every function and see what else the employee's doing. So it's possible, but I'm going to say probably typically not, but possible. I want to mention a couple of these points that I think are really critical to avoiding mistakes that lead to DOL audits. Lots of times your employees come to you first. One of my clients had a DOL audit last year, and we were getting ready for it, and we said, well, what do you think the employee could have been complaining about? And the manager sitting right there said, oh yeah, so-and-so came to me and complained about this practice. So we could have taken care of this up front by addressing it with the employee. And guess what? This employer had no violations. It was a big employer, and the investigation took a long time. No violations. So it cost them money, it cost them time. If they had just addressed the situation with the employee and explained to the employee why the travel time practice was appropriate, maybe they would have avoided the investigation. So really, number two, not explaining timekeeping and payroll practices to your employees. We feel like employees should understand that. They should understand their pay stub, but they don't always do it. So really educating your employees about timekeeping and how they're paid.
Just a comment on that. I had a similar situation where an employee read in the handbook, the time clock procedure. It said that there would be an automatic deduction for lunch break. And that's not actually what the employer did. The employer checked to see whether or not you clocked in and out for lunch, whether or not you took lunch. It had a process for reporting to supervisor if you worked through lunch. But the employee reading the handbook saw that it was automatic deduction, and we ended up in a lengthy Department of Labor audit dealing with trying to defend a practice that, or a policy that we didn't even follow.
So, the situation my client had with training your managers, if that manager had really kind of been alert to what was going on, that might have ended the situation. So really helping your managers understand that when employees raise concerns, bring it to HR so they can address it. Okay. Is there anyone here in person or on our webcast who would go to an IRS audit without their accountant? I don't see any hands here. This is a government audit. Call your professional. Make sure that you are prepared and that the audit goes well. So that's it.
In that regard, I mean, how many times do we get the call, the investigator, hi Miriam, the investigator is going to be here tomorrow. I have all the paperwork out. I thought I'd just give you a call and let you know that this was going to go on. Well, makes it pretty difficult for us to get you prepared. And you don't want to attend those, as Miriam is saying, without your lawyer.
Or the call of the DOL investigator came and I gave him all of this paperwork, and now he wants to have a follow-up meeting.
Yeah. Is there a problem?
There's a lot less we can do. Right. Our hands are tied if we've already produced documents. Then we're in more of a defensive position.
Yeah, DOL audits actually are pretty standard. Mm-hmm. The DOL has a script; they follow it. If you've been through a couple like we have, we can tell you almost to the letter what they're going to say and what they're going to ask for. So you can be prepared. And what you should be doing is gathering the documents. And first of all, the audit. We started out talking about the scheduling letter. Guess what? You can call them and ask for them to come later so you have time to prepare. They almost always agree to that if you're professional and courteous. Then you have time to get your documents together, go through a practice run. That's the best thing that can happen. So when they ask you, do you have any independent contractors? You'll know how to respond appropriately. Or do you have any people working here under 18? You don't start saying, well, my sister's son and this person, so you're prepared. You know the questions and you know how to respond truthfully and appropriately. Let's see, we got one more here. So the question is a good question. Does having exempt employees clock in and out and track days worked and for security purposes make them non-exempt? Absolutely not. You can clock, you can track the time for exempt employees for security purposes or even just to understand what it is they're doing. But if your exempt employee leaves at 2 o'clock, or you can't deduct from their pay, you have to pay them on a salary basis. So the timekeeping is separate from the pay for exempt employees.
And that ties into this question. That is, the individual clearly does exempt work, but works a flexible part-time schedule. 12 hours one week, 20 hours another week. If this person's paid hourly, does it change their exempt status?
Absolutely. Exempt is what you do and how you're paid. So your exempt duties, executive, professional, administrative, IT, a few others, and how you're paid, salary. So it's a good time for me to add, there are a few, I almost hate to put this caveat in here, few little categories of exempt employees who can be paid on an hourly basis, certain high-level IT professionals, high level, not your help desk, high level. Yeah, if you have someone who's working flexible hours and you're paying them on an hourly basis, then they're non-exempt, even though their duties might qualify.
All right, and as Miriam was saying, in terms of actually being in tune and listening to when your employees have complaints, oftentimes employers will miss the opportunity to address an issue when it first comes up. And miss it, what do I mean by that? That is addressing the situation internally and taking care of it right then and there. Frankly, at the end of the day, a good investigation, an investigation that demonstrates to the employee at issue that you care about their concern, that you have the policies and procedures in place to address that complaint, irrespective of what the ultimate outcome is, that is, you either find a violation or you don't find a violation, will go a long way in terms of keeping your employees satisfied and make it much less likely that they will go to an outside agency and file some sort of formal complaint. And so what are the common mistakes that we see in internal employment investigations? A big one's failing to respond or an untimely response. And it's imperative for those of you that have been through this that you address the issue promptly. Now, I have clients that will, oftentimes they want to sacrifice a quality for speed, okay? That is, we want to get it done, we want to address it right away, but the investigation perhaps isn't as thorough as it should be. It has to be done as quickly as is possible, but we never sacrifice quality for speed, okay? Some investigations, as we'll get into a little bit more here, are more complicated than others. I mean, oftentimes a complaint comes in, you can address it right away and put the investigatory file on the shelf and make a determination. Others require a lot more work in terms of interviews, in terms of document gathering, and of course the law will recognize the fact that you are responding as quickly as possible, but also investigating it thoroughly. It's important to have an investigator that's qualified, and we do talk about this a little bit more as well. That is, you want to have somebody that's properly trained. Oftentimes it is your HR director, your HR manager, but in certain organizations, if you don't have the luxury of having an HR manager or an HR professional in your organization, it can be an outside lawyer that comes in and conducts the investigation. Oftentimes I'll find we work with CFOs. They seem to wear this hat when there isn't a true HR department in an organization. But making sure, irrespective of the title of the individual, making sure that that individual is capable of conducting the investigation. That is, they're well versed in the issues, both from a policy standpoint and from a legal standpoint, and have been trained in how to conduct a proper investigation. Conducting an incomplete investigation, we all get busy. Business goes on, you know, despite the fact that an employee brings a complaint to our attention, whether it's harassment, whether it's discrimination, whether it's a potential wage hour violation. But we have to finish. we have to focus and finish the investigation. We always begin by saying, ultimately, when we're counseling clients through this, you will come to a conclusion. This investigation will come to a conclusion, and you're going to have to make a determination. Did a violation of your policy occur? Did it not occur? Do you not have enough information, or you're not capable of determining whether a violation has occurred or not? That can be a conclusion, and then we suggest some remedial action despite that fact. So making sure that you complete the investigation is imperative. It's important to consult with your employment lawyer in particular when you're conducting these investigations. Oftentimes we will work behind the scenes. I actually prefer to do that as opposed to doing the investigation ourselves. We'll do that when necessary, because if the situation goes bad, that is, the employee, despite our best efforts and despite a thorough and proper investigation, goes ahead and files a complaint anyway, we become a potential witness in a situation where we're the actual investigator, and it can prohibit us from defending your organization in that. So I like to be working behind the scenes in terms of coaching and collaborating with your professional that's conducting the investigation. And it also gives us the auspice of privileged communications, which is a nice thing to have as you're kind of working through it. And again, I'll talk about that a little bit more. It's important to take action once an investigation is concluded. And we'll talk about a little bit more about what proper remedial action is. You got to communicate. It's important. The employee that complains and brings a complaint to your attention wants to know that you did something about it. Even if ultimately you determine a violation did not occur, he or she needs to be told that, so that they know that you did a proper and thorough investigation. Again, it demonstrates to our employees that we take these issues seriously. We did what we were supposed to do, and a determination was made. We often get the question of, well, do I need to tell the complaining employee exactly, let's say, for example, I fired an alleged transgressor in a harassment situation. Do I need to tell them that precisely? No, I don't need to tell them that. You know what? They'll find out because, John Doe or Jane Doe won't be there anymore. But we do need to let them know that we took appropriate remedial action, took appropriate steps to make sure that this conduct didn't occur again. And then we always have to be mindful of retaliation, okay? That is, a complaining employee that comes to us, we assure them that we have a zero tolerance for retaliation. We thank them for bringing an issue to our attention in good faith, and we inform them that to the extent they believe that there's been any conduct that's retaliatory in any way, shape, or form, that they alert us immediately. That's critical. Of course, when we go and interview the alleged transgressor in again, I'm going to a discrimination or a harassment type of complaint, we are letting them know that there is zero tolerance for retaliation, and to the extent that any of that conduct occurs, it will be dealt with accordingly as well.
One other kind of common mistake is that at the beginning of the outset of the investigation, employers sometimes skip over the part of laying the groundwork for the investigation and the ground rules of how this is going to work for the employee who has complained. So explaining that there is a confidentiality, attached to this process, that you will be talking to other individuals who may have relevant information, so that they're aware that, the person that they've accused, their boss, may, be asked questions. And then also telling them that this is the time to tell them you won't be retaliated against for raising this as an issue. So you have an opportunity to set those ground rules in the framework.
Yeah, I would add one other to those two, which is setting unreasonable expectations. So I've seen this a couple times recently where employees seem to think that when you say prompt investigation, you mean immediate investigation. Well, as Jim said, it takes some time to do a complete investigation. So you should let the employees know as part of those ground rules that it's going to take some time to get the information you need. You're not going to have a response to them the next day. Maybe it won't even be the next week. Help them understand what the time frame is.
And in that regard, it's important to keep them apprised of the status. That is, we're still investigating, and we expect to have a conclusion by X date. And if you don't meet X date, at least you're checking in with them and saying, we need to do more, and we expect to be concluded by the next date. That is, by doing that, you're engaging them, you're letting them know that you're taking it seriously, and you're letting them know that it's on your top of mind to complete that. So again, I agree. You've got to set those expectations accordingly. And relative to confidentiality, as Nicole brought up, we get this question all the time because oftentimes when people come and complain, you'll get this, and I was going to tie that into this slide anyway, but that is, John's making me feel uncomfortable. He said X, Y, and Z to me. I really like him, though I don't think he meant anything by it. So I just thought I'd let you know, and if you could just keep this between us, then let's just move on. Well, it's important in that situation to, number one, let them know, thank you for bringing this to our attention. That's what we want you to do. That's why we have this anti-harassment policy. As you can see right here, it says you're supposed to bring this complaint to me, so you did the right thing. And as to your request to just keep this between us, I can't do that. Understand that. From both a policy standpoint and from a legal standpoint, I would not be fulfilling my obligations if I did that. So I'll keep it as confidential as I possibly can, but I have to at least share the allegations with the alleged harasser in the situation that I'm describing, or the witnesses that perhaps you've identified, to make sure that my investigation is complete and I'm able to come to a reasonable conclusion about a policy or legal violation. So what are some of the, speaking more specifically about some mistakes in internal investigations, not listening to our employees when they bring a complaint to our attention. You're not always going to get the employee to make the complaint in nice and tidy language. Jane, I think a violation of the anti-harassment policy took place because Frank said this and he brushed up against me, and I see right here that if it's severe and pervasive, then there's a violation of maybe the law and I know of our policy. Well, it's not going to be that, it's normally not going to be that tidy, right? And we're not going to get that legal jargon relative to, setting us off that, hey, there might be, I better take the employee handbook out because we might have a violation of the policy. So listen to what's going on. So for example, using that example, John's making me uncomfortable. He said this comment to me, he said that comment to me. I don't think it's a big deal, but I thought I'd let you know. I mean, that's a tip-off that we're going to have to conduct an investigation there. And whether or not the employee cites to the policy, whether or not they're using all the nice words like, even though we need to be in tune relative to claims of gender, race, disability, etc., but they might not be using those buzzwords. We need to be in tune enough and train our managers well enough to know if, in fact, we have a complaint that triggers our policies. As Miriam was talking about, unpaid work time, don't just brush them aside, okay? That's an important area. And in tailoring our investigation to the complaint, I mean, with a wage hour complaint, that could involve a whole class of employees potentially, to the extent that an individual is claiming that they're not being compensated fairly, and it involves a broad class of individuals. So be sure that you're tailoring the investigation to the complaint that's actually made.
This also comes up sometimes when an employee will say has been absent for illness and says, yeah, my supervisor keeps writing me up and I'm out sick. They haven't really, they're not saying hostile work environment, which, by the way, that's really the vast majority of internal complaints that I see is those are the buzzwords that employees are using. I feel I'm in a hostile work environment when things are going badly with their performance or whatnot. But if you don't have that type of situation where it's not really a harassment issue, but it's a situation that may be that the supervisor is disciplining somebody for attendance that's related to a disability issue. So something to be mindful of.
It's funny, oftentimes too, complaints will find amount to personality clashes or people don't get along. And it's important to recognize the distinction. That is, the law and the policy doesn't or isn't meant to implicate, if you will, somebody that's maybe a crummy manager, doesn't speak to people nicely, isn't able to motivate them in the right way. Might not necessarily be a violation of the law or violation of policy because they're an equal opportunity jerk, right? That is, they treat their male subordinates and their female subordinates, their African American subordinates and their Caucasian subordinates in the same way, but it may be a trigger to us that we have somebody here that might not be well suited to be a manager. So understanding those distinctions is important. I talked briefly about selecting a proper investigator, somebody that's trained properly in your policies, how to conduct an investigation. Again, generally comes from HR, legal, risk management, can be outside counsel. You want to have an impartial investigator, right? So if your HR manager is at the crux of the allegation, probably not a good idea to have him or her as your investigator in that context. We want to make sure that we're maintaining impartiality. Make sure that we have the proper resources to the extent they need to consult with outside counsel. Make sure that that resource is available to them. It might be that we have to go through records. We might need to involve IT. I can't tell you now how many of these investigations now involve a combing of email communications or text communications. Social media now has become a big part of these types of complaints and investigations. So we have to be mindful that necessary documents, necessary evidence, if you will, may be found in a myriad of places. So we have to make sure that we're covering all the bases. Planning, like anything, is important. That is, this policy and procedure, my investigatory team, relative to it being a designated person in HR, they have someone that assists them, should be in place before a complaint darkens my doorstep. We don't want to play catch up with these situations. We don't want to be reactive. We want to be proactive. So we are ready to go when and if a complaint is levied. That is critical. So taking the time now to make sure that your policies are updated, to make sure that your managers and your HR professionals are trained is important. We do a lot of on-site training for clients where we'll specifically meet with their management team and go through how to properly conduct a thorough workplace investigation that's tied to your policies and procedures so it has real relevance in your organization. Something to consider taking advantage of. We do that a lot for clients. As I mentioned, you've got to be flexible enough to have the investigation grow or contract as you see. For example, I recently had an investigation that I was assisting a client with that started out as a single individual making a complaint regarding alleged sex harassment. Well, in looking into the individuals that she claimed were also witnesses and or involved, it became clear in an investigation that really took about 2 weeks to interview all the parties, to gather all the relevant documents. It became clear that she didn't have a valid claim, but these others that she had identified, there was a lot going on that we weren't aware of and that these individuals hadn't brought up before. So despite the fact that the original complaining party, we didn't find that a violation had occurred there, our investigation was flexible enough to account for the fact that we did have some systemic problems elsewhere, and it allowed us to address the situation right then and there. So obviously our investigation expanded in that situation as we learned more and spoke to more individuals, and we kept going until we were satisfied that we had captured all of the relevant individuals that were affected, got the relevant time frame down, and then suggested remedial action and effectuated remedial action to address it. We even went back to the complaining party in that particular example that I'm talking about and told her we didn't find a violation had occurred here, but we did find evidence of other violations, so we're taking remedial action, and we didn't use the word, we're taking proper measures, okay, to address the situation. She wasn't real happy with that conclusion because we couldn't substantiate her complaint, but that's not our job, okay? It's not our job to make sure that we want to make our employees as satisfied as possible, but we're not going to validate every complaint, right? So it's our job to do a thorough investigation, to communicate the results, and the results dictate what we do in terms of follow-up. It's important as you're conducting an investigation, emailing, like amongst HR professionals or amongst the individuals at issue in HR, we can't be casual about our communications regarding an investigation. It's all going to be discoverable, ultimately. That's why it's important to involve, in my opinion, and this is somewhat of a shameless plug, your lawyer. Okay, that is, in the situation I was just describing to you, the individual that was handling that investigation, that individual would email me the results under the auspice of privilege and say, this is what I discovered, this is my suggested next steps, and we would communicate under the auspice of the privilege and very likely protect those types of communications from production when and if litigation ensues. So let's not be afraid, if we need to talk to somebody, to get up out of our chair and go and talk to them. You know, we're not creating an electronic trail of those communications if we actually speak to people face to face. You can still be asked about what your conversations are, okay? If you're not consulting with counsel or some other type of situation where privilege would apply. But at the end of the day, as we all know, we can tend to get a little careless in emails. We can tend to get a little careless in our text messages in terms of editorial, things like that, that we wouldn't want to be out there when and if the employee at issue brought a claim.
And not just careless too, I mean, that's a very good point, but also it's an awkward process. It's uncomfortable. And sometimes if the person who's conducting the investigation doesn't have the proper training, hasn't done it very often, and especially in a smaller employer where you know these people and you see them, you deal with them on a daily basis and probably have worked with them for years, it's easy to get into a pattern of being more casual during the investigation process. And in fact, I actually had a situation where the investigator was interviewing the accused, and it was just the investigation had just begun, and she said, because she felt awkward and uncomfortable, I'm sure we won't find anything, but I have to do this. And that's a difficult thing to explain, why she had made that decision as the investigator before conducting any investigation.
In terms of investigating, you as investigators or your investigators, they have to make determinations. We have to make a decision. I've oftentimes seen investigations that kind of wallow into obscurity because our investigators aren't willing to make credibility determinations, for example. You have to size people up. That's why you want to interview people live. I hate, to the extent I can avoid it, telephonic interviews, because you can tell a lot by looking at somebody. Have a corroborating person there with you. You know, that person is there to serve as a witness in the event it's called into question what your discussions are, etc. That person usually is not saying a lot. They're taking notes, etc. There is an individual that leads the investigation, but it's important to have a witness, if you will, there. And make a determination. We are making a decision. I can't stress that enough. Okay, this isn't going to end with I can't make a determination here. Now, the determination, as I said, may be I can't determine that a violation has occurred here. But as a result, I'm going to recommend that the entire department have anti-harassment training or sensitivity training, just to make sure that people are aware of how we conduct ourselves in the workplace, what we do if we feel there's a complaint. That's a proper conclusion to an investigation, but we are making a decision. And when we find that a violation has occurred, then we are recommending the appropriate action, whether that's termination, whether that's suspension, whether that's a written reprimand. And of course, precedent plays a part there in terms of like-kind violations. What have we done in the past? The seriousness of the offense, any aggravating or mitigating circumstances. All of this is taken into account in meting out what action should be taken. It's important as we conclude that we follow up, as I mentioned at the beginning, with the complaining employee. Thank them for bringing their complaint to you, ensuring them that a thorough investigation was done, that appropriate responsive action has been taken, and remind them of the zero tolerance for retaliation. And it's important throughout the process to remind witnesses, the complaining party, and the alleged transgressor that you do have a zero tolerance for retaliation. That's critical. Now, Nicole's going to speak about when our internal investigation doesn't necessarily resolve the issue.
So if you've taken all of Jim's good advice and you've done your investigation, and that may not resolve the issue for the employee. The employee may go out and file a charge, may seek counsel, or it could be a situation where it wasn't even something that you had an opportunity to investigate. It's something that is brought to your attention after termination. So someone's terminated and they go to a governmental agency to file a charge about being terminated. Or worse yet, they're still employed with you, and they decide instead of coming to you directly, they want to go to seek outside external help. So we've talked about the Department of Labor. We've talked a little bit about the Equal Employment Opportunity Commission, which are the federal agencies, but there are state equivalent agencies that employees can go to as well to pursue charges of civil rights violations as well as wage and hour, for example. And when we're talking about the Department of Labor, Miriam focused primarily on wage and hour issues, but the Department of Labor administers and enforces more than 180 federal laws. So we're talking about things like the Family Medical Leave Act, the USERRA, which is the Uniformed Services Employment and Reemployment Rights Act, OSHA. So the Department of Labor has a broad range of claims that employees can bring to it that it would then investigate. And just a point about OSHA, it's always sort of the forgotten about piece of employment law, but OSHA certainly has increased, and the Department of Labor has increased its budget for enhanced inspection and enforcement activities. And so I've actually seen an increase in OSHA charges, which I had very little experience with a few years ago, and now there's been more. But I would say the most common response that we see from an employee who's unhappy with an employment-related situation is going to a governmental agency and filing a charge or a complaint. One, because it's free. The government takes up the investigation on the employee's behalf. And also because the government itself is reaching out to employees. The government's using social media to advise employees of what their rights are and telling them how they can contact the government and things to look for in their workplace. So you should be aware of that as well. So if you get a charge, or likewise, while the charge is the most common, something we also see is an attorney demand letter. You get an attorney who has sent something on behalf of an employee to your attention, or just a private lawsuit. So when you get those, the question becomes, so how do we respond? And one of the most common mistakes is failing to respond or having an untimely response. And my advice is don't ignore certainly the charge if it's a governmental charge, but even the attorney demand letter, even if it's full of misrepresentations or false allegations, don't throw it in the trash. Because a lot of times they will be a starting point of some kind of negotiation where you could resolve something quickly, or they at least give you an idea of where this employee is going with future claims that may be brought. They can start you to be able to strategize internally of how you would handle this if something came from it. And most importantly, that attorney demand letter has now put you on notice of a potential claim. So that may trigger some preservation obligations that you have as an employer to preserve electronic information as well as hard copy documents that you have about this employee or relevant to that employment situation. And also, agency charges have response dates. They are, either 15 days if you're in state, or 30 days if you're in front of the EEOC. So you have quick turnaround times, and you want to make sure that if you need more time, you're asking for more time. You're not just blowing off their deadline. The government likes nothing more than to say that you failed to respond in a timely manner.
And then you're going to end up with a subpoena.
Right, like the DOL, the EOC, and the state agencies usually, if you're professional and courteous, you can usually get an extension, because they are, your employee might wait months to bring a claim, and then you have, 14 days to respond. But make sure that you respond appropriately.
Well, and a couple other things we see are too easily or readily providing information and documentation. And a lot of times an attorney letter will demand a copy of the employee personnel file. And whether or not you provide that information should be a strategic decision, and sometimes is required by law, but at least here in Ohio, we don't have a requirement to provide a personnel file to an employee. It's the company's property, so we should assess that and determine, is this something that we want to provide?
Which is a good point that Nicole raises. In Ohio, it's not a requirement. In Michigan and many other states, it is, Illinois. So, it's important to understand the state laws with regard to these issues, and also with regard to your state wage hour issues.
And so sometimes employers just turn over an employee personnel file. Maybe we want to do that, maybe we don't. Likewise, governmental agencies, if anyone's gotten an EEOC charge lately, there is a full 2-page document that is attached to it that's called Request for General Employment Information. And if you're getting an EEOC charge, you're not familiar with responding to them, and you just start producing all of this information, like your prescription drug coverage and any and all employment conduct policies. Who knows what that could cover? So too readily providing information without reviewing it and seeing what's really necessary here.
Nicole's right in that regard, and it's a very good point. That is, overproducing. They're looking for not only relative, as we've touched upon here today, the individual at issue, but your practices generally, because they want to generate a little potential income out of this investigation, whether it comes out of the individual complaining, or perhaps there's something wrong with your one of the policies in your handbook, or your application isn't up to snuff. I mean, we generally like to give, in terms of responding initially to a government charge, as much as we think is necessary for them to make a no-cause determination, subject to whatever requests we may get and how we're able to craft objections, etc. So it's important to really evaluate what is required to be produced, at least initially.
Right, and to piggyback on that as an example, I had a client who gave a charge, who had a charge of age discrimination, and they responded, and the person was terminated due to theft. It was very open shut, as they felt, and later on was determined. But in their production, they did it on their own, and in their production, they produced their full employee handbook, as well as some other policies that they had. And we spent over a year arguing with the EEOC as to whether or not an attendance policy was a violation of disability law. And I remind you, the charge was age discrimination. Had nothing to do with one another.
Let me just add that if you happen to get an unfair labor practice charge in front of the NLRB, and you can get one of those even if you're a non-union employer, the same thing applies. The NLRB loves to look at your employee handbook and find policies that violate the National Labor Relations Act. So it's really important to be careful in dealing with the National Labor Relations Board.
And just quickly, a few common mistakes are inconsistent response. So an employer gives one reason for a termination, and in the same document gives another reason. So first says it was a layoff, and then second talks about poor performance. And this sometimes can happen by, we respond to the charge, but then the employer also gives unemployment documentation where they've termed it something different than what was in the response to the charge. And then delayed notification to outside advisors. And here, this would include your insurance carrier. If you have employment practices liability insurance, you want to make sure you're timely notifying your carrier so you don't have a denial of coverage issue. So what do we do to avoid those common mistakes? And here, I'm was going to say to Jim's, he said it was a shameless plug. I agree. Call your attorney. That's what we're here for. This is our job. We're experts in this area, and we see it all the time. Where you may get an EEOC charge once a year, we are dealing with one once a week. So, that's something we're here to help provide a strategy. And even if we don't do the response for you, we can certainly help to provide a strategy as to how to assess the situation. You want to make sure that you designated a point person for who's going to understand this charge, this claim that's being made by an employee, current or former, and that they understand the timeline of events and what that narrative is. What's your story as to the termination? If you have a termination that occurred, a termination notice that says the termination is effective March 15th, and the date of the termination notice is March 20th, and it wasn't given to the employee until March 25th, you need to explain that and have someone who is able to understand that situation and explain that. You want to make sure you're gathering relevant documents whenever you get a charge, for example, that you're collecting the personnel file, making sure that if you've cited to a policy violation, you've terminated this person because of a policy violation, you have a copy of what the policy is if it's written, so that later on it's very clear what the policy was and we're not fighting over which policy was in effect when. Also, you want to identify key witnesses. Who are the decision makers? And importantly, what are their last names? I cannot tell you the number of times that I have seen a termination notice that just says Jeff. 4 years later, because our statute of limitations for state claims in Ohio is 6 years, 4 years later, people don't know who Jeff is. So use your first and last names, make sure you're understanding that, and what's their current job title at the time they're making the decision.
It's important, and I'm jumping ahead to our fourth presentation, again, a little teaser, but when you're terminating an individual, it is preferred that you put in writing, I believe, what you terminated them for. Don't hide. I can't tell you how many times we see, we're going to exercise our right as an at-will employer and let you go because I have an itch today. No, you're letting somebody go because they didn't show up to work for 5 days in a row, and that's a violation of your attendance policy. Or they engaged in other misconduct. They damaged property. They were under the influence at work. Say it. It's important to say it, because I guarantee you, if you don't, you're going to get a different explanation from their lawyer, and then you're going to come back and say, oh no, it really was because of this. Well, then it just looks like we're manufacturing a reason after the fact. So, you know that saying, the truth will set you free? It will. So let's not be afraid to say it, and say it early and often, and put it in writing.
Well, and as Miriam said at the beginning, when you open up your mail and you see the Department of Labor on an envelope, it's not a great day. Same with an EEOC charge or a letter from an attorney. However, let's view it as an opportunity. It's an opportunity for us to assess the situation as a whole. We can do a factual analysis, right? We want to know the basics, so the who, what, why, where, when, how, right? We want to know what's our narrative and how does that compare to what the employee is saying. Assess the potential holes in both our case as well as the employee's case. So if we fire them for disciplinary or for performance issues and we have a bunch of glowing performance evaluations, we need to know that, and we need to assess that early on. Same with then, this gives us an opportunity to do a legal analysis of the claim. And we need to know what are the legal issues that we're going to have to contend with, and how do we defend against those? Is this a breach of contract issue? Are we looking at a document? Is this a harassment issue? Had we already done an investigation? We need to understand, is this something that is a potential willful violation? To Miriam's wage and hour issues, is something we had gotten slapped on the hand by the Department of Labor before and we didn't correct, or not? Also, is this a single plaintiff claim? Is this one individual claiming that they were individually discriminated against and they had one adverse action, termination? Or is this an individual who may be the lead on a class? Is this a practice that they're claiming is unlawful? Is this a background check issue. We didn't file the Fair Credit Reporting Act notice requirements before not hiring them. Those types of things we need to assess early on. And
another reason to get your lawyer involved is because sometimes we can look at the charge and see that they're trying to set up a class type claim. And I've had that happen a couple times recently. The EOC is really interested in class claims. That's how they get more money. And so they're writing these charges broadly to say that policies affect a whole class of employees and not just an individual.
Exactly. And then we need to use this time to assess the outcome, right? What are the potentials, what's the risk? What are the potential damages if this individual is successful? What's the cost in defending it? You know, understanding some of those things to the extent that we can up front is important to know. And then also, is there a potential to resolve this up front and quickly? Can we go to mediation with, if it's an EEOC charge with a current employee who maybe didn't understand or there's some confusion about, you know, about an attendance write-up? You know, is it something that we could address in a relatively easy manner at mediation, or is it not? So those are things that we need to assess early on, and especially once we're getting that charge in the door. Just in general, common mistakes that lead to employment law violations are being reactive versus proactive, waiting for something, you know, keeping our heads in the sand and saying, well, nothing, we've had status quo for a while, we haven't really had any charges, we haven't had any audits, I think we're fine. You know, employment law compliance continues to be an area of increasing risk for employers, and you, if you're being reactive, it's too late. The issue's already out there, and you don't have the opportunity to address it and get in front of it. And then not monitoring your internal employment practices or your policies, not training your managers. I mean, show of hands quickly, when was the last time that you actually updated your employee handbook? Okay, I got 2 hands.
Looks like we'll be talking to all of you after the program.
in Cleveland.
Yeah.
So, and I'm sure on the web as well, it's one thing to look at your employee handbook and review it every once in a while. It's another thing to actually invest the time to update it and make sure that your policies and practices are up to date. And then your managers are your first line of defense. They're the ones who the employees are going to, and they're your eyes and ears, you know, out in the facility. So ways to avoid that are to conduct some, you know, ways to avoid employment law compliance issues are to conduct compliance self-audits. The EEOC has indicated that their vision under their strategic plan is to ensure justice and equality in the workplace by all means possible. If that doesn't scare you, it should, because they're coming after you and they're saying, employers, you need to be monitoring your internal workplace and understand your practices and policies, and they want you to conduct these self-audits. So be proactive. It's something you can control. A lot of things we can't control. We can't control an employee going out and filing a charge or filing a lawsuit, but we can control the internal workings of our employment law policies. And use your handbook as a tool. Update it, review it, use it as a tool for the workplace, and arm your supervisors with that knowledge and the skill to at least issue spot. They may not be the one to handle the matter, but they should be the ones on the floor that can at least issue spot. If somebody mentions, you know, health conditions, right? They should at least, that should ring a bell for them to go talk to somebody else. So when you're conducting an effective self-audit, it's overwhelming. There's a lot. So, you know, one way to tackle it is to do bite-sized pieces. Take pieces of the employment relationship and pieces of that process and have that be an area of focus. Because guess what? The EEOC is taking pieces and they're addressing the certain areas of focus. I mean, hiring process, that has been and is going to continue to be very much a focus of the EEOC. So review your employment applications, your background check policy, how are you dealing with criminal records or criminal convictions and I-9s. And make sure that you're enlisting outside help when possible to do these audits. You know, to the extent that you're doing a wage and hour audit, then you would want to involve an outside attorney. Maybe try to cloak some of that in a privilege so that you can review and assess your workforce.
So in terms of what we want to leave you with today, and we hope we've left you with today, is first and foremost to be proactive in terms of making sure that your policies and your procedures and your personnel are up to speed and well trained. Making sure that you have those you take the time to conduct those self-audits to shore up any deficiencies that you may have. To respond promptly, as we've talked about ad nauseum today, to internal complaints to try to avoid issues before they get out of hand, all in an effort to avoid government investigations. One point I just want to end with that Nicole brought up, in terms of actually taking your handbook off the shelf and reading it and finding what your policies and procedures, there's only one thing worse in the world of employment law than not having a policy. And that is having a policy and not following it. That is, you might as well shoot yourself, because at the end of the day, if we say we're going to do it and we don't do it, it really can come back to bite us. So it's worth your while to go ahead after this program here today and at a minimum take a look at your handbook and your policies and procedures. So we didn't get to some questions that we had here, so we'll be hanging out if you want to here in the office. And I think there were a couple of web questions we didn't get to, so we'll follow up via email. And we want to thank everybody here for attending. Have a good afternoon.